Okay, welcome to Plenary 6, the last panel discussion for this day at the EuroDIG. The title of the panel is A Secure and Non-Fragmented Cyberspace, Rule of Law in a Cross-Border Environment. I'm very happy to be the moderator of this panel. My name is Oliver Süme. I'm the Deputy Chair of the ECO Association, which is hosting this wonderful conference, and I'm also President of EuroISPA, which is the European ISP Association. We are the largest ISP association in the world, representing currently roughly 2,300 ISPs across Europe and the EFTA countries. And we are engaged in quite a couple of years in internet governance and also at ICANN. And I'm happy to start the panel now. And before we start with the discussion, I would like to introduce the panelists. And I start with Professor Dr. Gian-Pier Mifsud-Bonici on my very left side here. John holds the chair of European Technology Law and Human Rights at the Department of European and Economic Law at the University of Groningen. Next to her, we have Nicholas Landsman. He is running a political consultancy since many years, and he's also been the Secretary General of the UK ISP Association, ISPA UK. And this association has grown very much from a handful of ISPs back in 1995, and nowadays I think, Nick, you're representing over 250 ISPs, which covers roughly 95% of the UK internet market. Next to Nick, I'm happy to introduce you to Tatjana Tropina. She is also our reporter for this session. Tatjana is a senior researcher at the Max Planck Institute for Foreign and International Criminal Law in Freiburg, Germany. And next to Tatjana, we have Jan Malinowski. He's the head of the Information Society Department and the Directorate General of Human Rights and Rule of Law at the Council of Europe. Thanks for being here. And well, let's start with the session. I already mentioned the title, and if you go to the wiki and the program of the EuroDIG website, you will see that there's also a subtitle, which is Multi-Stakeholder Approach to Cybersecurity, the Role of Intermediaries and Law Enforcement. So we're not only talking about a fragmented or non-fragmented cyberspace in general and the rule of law. We would also like to discuss the role of intermediaries and the ways for a multi-stakeholder approach to cybersecurity. If you attended the last panel, then you know that security was already discussed there. We have a slightly different approach. There might be some overlapping, but we will focus on if, for example, national laws have an impact of a fragmented or non-fragmented cyberspace. And before we get into the discussion, I would like to ask the panelists for a very first statement. I already introduced you, but we would be happy if we would hear just some remarks on what your view on cybersecurity and a possible impact on a non-fragmented cyberspace would be. And I would like to start with Jean, please.
Thank you very much, Oliver. To be honest, when I read the panel title, I was quite taken aback. How does security and non-fragmented cyberspace have anything to do with a rule of law? And what do we mean by non-fragmented cyberspace here? So I'm very keen to develop that during our panel and think of what types of fragmentation we're thinking about. I think most of it is going to relate to law, but are we also thinking of fragmentation from a technological perspective, is it borders that we're talking about? What is it that we'll be talking about?
Hi there. So I think the issue of definitions came up in the previous session. I think that also applies to this session. And earlier in our discussions, we were talking about the problem we have in defining cybersecurity. And I'm sure this will be worthy of a bit more detail, but just as an introduction, we have the term cybersecurity used for international cyber warfare, corporate espionage, attacks on national infrastructure, fraud of companies, and what I mean by that is targeted attacks on companies where perhaps larger sums of money are being extorted. And then we also have fraud of individuals where small amounts of money are extorted from large numbers of people. And all these, I suppose, are forms of cyber crime and need to be addressed by security. And I think we do need to drill down in this session into what exactly we're talking about to have an effective discussion and debate.
Yeah, thank you very much. It was really a good starting point for me as well. I also see lots of misconceptions and confusions about security because, well, people do confuse terms. For example, we are talking about public-private partnerships in fighting cybercrime, and people confuse these with public-private partnerships for national security and countering cyber attacks on the level of cyber war, which will have different stakeholders and different consequences. And I also believe that this confusion contributes to what we call fragmentation of cyberspace, because recent revelations on surveillance and so on made some countries, like for example Russia, talking about information security in the realm of national security and telling, okay, we have digital sovereignty, we have to have our own sovereign segment of the internet where we can exercise our powers, our duties, and to protect our citizens. And I believe that these debates are mixed with the debates on cybercrime, where stakeholders and frameworks would be totally different compared to national security. So coming back to the issue of this session, I believe that we probably have to discuss all these and also discuss these differences between different dimensions of cybersecurity.
Well, I think that it has already been said to some extent. There is an overlap, but there is no identity between cybersecurity and cybercrime. If we are talking about cybercrime, the way in which it is dealt with in different jurisdictions will not have necessarily an impact on fragmenting the internet. It will mean that there are different legal regimes and different consequences for the activities that people engage in different parts of the world, and it may have the impact of weakening the protection of the users or the systems and so on, but it won't necessarily have a direct impact on fragmenting the internet. That is why there is a need for harmonization in the cybercrime space, which the Council of Europe does with the Cybercrime Convention.
Thank you. Thank you for mentioning the Cybercrime Convention, because maybe it's a good start for the discussion if we talk about the institutional framework, about the legal framework that we have for cybercrime and cybersecurity. When I was preparing the session, I noticed that the Cybercrime Convention will have its 10th birthday in a couple of days. It was enforced in July 2004, and as I'm not sure if anybody knows what the Cybercrime Convention is, Jean, could you please wrap up a little bit the Cybercrime Convention? What kind of framework is it? What impact does it have on national laws? And what is the idea behind it?
It is, okay, let me start from the very beginning. It is a piece of international law, so it is a convention. What it means is that it brought together a number of countries together to discuss how do we take forward cybercrime. What it does, it defines certain activities and identifies them as falling within the criminal realm as cybercrimes. And indeed, there are a list of these crimes. If one were to quickly look at the Cybercrime Convention, it covers a lot of the crimes that we hear about every day. Illegal access, illegal interception, data interference, system interference, misuse of devices, etc. It also, so basically it defines a number of crimes that can be called cybercrimes, and it gives also a number of powers or processes that police can, or law enforcement can use to collect evidence for these crimes so that these crimes will be prosecuted. Like any other international law, States have to first sign it and then make it part of their legal system. And 42 countries have done so. And what you were referring to, Oliver, it came into effect 10 years ago, and in these 10 years, it has been put into practice. There are a number of mechanisms that law enforcement can use to collect evidence across borders for these types of cybercrimes. That's, if I can put it in a nutshell.
Okay, so but this sounds like a bracket, right, for a legal framework in these 42 states that signed the contract. And this sounds like there is a non-fragmented institutional framework for cybercrime, at least. However, national laws might be different, and I heard from Nick that there have been some recent activities in the UK regarding not only cybercrime activities and the cybercrime laws, but also activities on a self-regulatory basis together with the ISPs. Could you?
I'll just quickly say one word about what you said. There's no fragmentation. There are different levels of how you could define this term. You either belong to this group of countries that have passed this legislation, or you don't. And there are a number of countries that aren't. The US is in, but other countries are out of this. So there is a level of fragmentation there. And that's not something we should be striving for. We need to remove that fragmentation. Yeah. I'll pass it on to Nick for the other.
Would you say that for those who signed the Cybercrime Convention, that this is at least a good basis to avoid a fragmentation of laws and a fragmentation of the internet? Is that a kind of?
It's definitely a good start.
Yeah?
It's not yet perfect because it's implemented in different ways in different countries. Yet, it is a good start to avoid this fragmentation. And why don't we want fragmentation? Because otherwise you have criminals avoiding the system.
Okay. Thank you. Let's hear something from the UK, and after that, Tatjana, I saw your face and it looked to me like you have a different view on that, but maybe we can do that in the next step.
So, I suppose this is where we might disagree, which will wake you all up in the last session. Laws rarely prevent what they forbid, and I think it's wonderful to have this umbrella of law that may or may not work, but we all know that in the technology sector, laws cannot keep up. As soon as they're written, they go out of date. And of course, what we're talking about on this panel is a global issue of cybercrime, and obviously laws, even when they are transposed from a European level into a national level, there are many differences in that process. So I do think this is an area where a multi-stakeholder partnership approach can play a part. I'll preface that and I explain what I mean, that we do need a legal underpinning for various reasons. But just one example, last year in the UK government passed, well not passed, it wasn't a law, it was a guiding principles on cybersecurity. You can see it on the UK government website. And what it was is an agreement between UK ISPs, including ISPA, and the government. And there's three parts to it, one of which is what can the ISPs do to help reduce cybercrime. And the element there was for ISPs to be able to inform their customers about what tools were available, to warn if there were attacks and so forth. From the government perspective, there was the setting up of the NCA, the National Crime Agency, to look at these sorts of areas and also inform and provide education on these areas. And the third area was working together, both government and industry working together to again educate people about threats, whether they're viruses, botnet attacks and so forth. Now it's a start, it's not perfect. And when before I said it can only go a certain distance without the need for underpinning. So one of the particular areas in the UK we've been looking at is how far should ISPs go to stop attacks and PCs and computers and laptops being infected. And of course, from the government's position, they would like the ISPs to block PCs that are infected. So an IP address gets sent to an ISP and the ISP goes, will warn the customer, will also block their computer. And obviously that's a step too far. And while the industry in the UK has done it for child abuse images, and so Richard in the last panel explained how that process and that it was proportionate, in this area, the concept of ISPs just going ahead and blocking people's PCs was a step too far. And the response from the industry would say, well, no, we need a court order to do that, or you're going to have to update the law. So we are in a position where a certain amount can be done, and we're going to be seeing, because 2 weeks ago there was a warning from the National Crime Agency that because of the imminent 2-week attacks, we have to be aware because thousands more PCs will be infected. So I'm expecting on Monday another announcement, either that the world will fall in or that maybe they were slightly exaggerating the issue. But either way, I think these principles are a good step in the right direction, because fundamentally we do need to explain, educate and provide tools for users out there to protect themselves.
Thank you, Nick. Tatjana.
Thank you very much. Actually, I would like to make a short disclaimer first, because we've got a member of the organizing team, Bertrand de la Chapelle. I believe that we will have to give floor to him after to explain his position on non-fragmented cyberspace, because it would be very interesting. Because it's not only about legal frameworks, but coming back to the issue of legal frameworks, I do believe that Cybercrime Convention is an amazing instrument. Because it's not only influenced legislation in Europe, because it influenced some of the European documents, like, for example, European framework decision on the attacks against information system and so on, but it also influenced some countries who didn't sign this convention or didn't join the treaty, but still in some African countries, for example, or in some Latin American countries, legislation is based on Cybercrime Convention. But back to the fragmentation of legal frameworks, before convention is in parts, it's fragmented itself. It's like, for example, take one simple crime, illegal access to computer system. Convention provides several options, like illegal access which is committed with dishonest intent, bypassing security measures, and so on. And an interesting thing is that this fragmentation in pieces comes from legislation which already existed in different countries who were drafting Cybercrime Convention. And of course, they didn't want to amend their laws, but they want to put all the stuff in there. And now it's like a patchwork of different norms. And concerning implementation, for example, implementation of European framework decision, again, crime on illegal access, there is an opportunity not to criminalize cases of minor importance. And if you go to the countries and see what they mean, case of minor importance, you will see case which didn't cause big damage. Is it a case of minor importance? Is it really what legislator meant? I mean, having an amazing instrument is one thing. How you actually implement it is totally different thing, and it does contribute to the fragmentation from legal point of view. But really, I think that we can give the floor now or later to Bertrand with his position on non-fragmented cyberspace.
Very happy to do so, Bertrand. If you are ready, I mean, you're near the mic anyway, so. Bertrand and Paul were part of the organizing team, so indeed we had some discussions in the various phone calls about the title and the content of the session. Happy to hear your view, Bertrand.
No, it's just unplanned. Thank you, Tatjana. Just one thing that I can contribute at that stage is when we talk about fragmentation, there might be an interest in the discussion to make the distinction between the fragmentation of the infrastructure itself, like the IP addresses, the domain name system, and so on, and the fragmentation of the legal framework applicable to cyberspace and what people do on the internet. Because it is less likely that there will be a fragmentation of the technical naming system because everybody wants it to remain completely interoperable. On the other hand, on cyberspace, the legal framework is fragmented today because it is the national basis, whereas for the naming and addressing system, it has been conceived as a non-fragmented and non-territorial thing. So there is a dissymmetry here when we talk about fragmentation, because the technical system is not fragmented and is likely to remain so, whereas the legal framework is fragmented as a starting point, and harmonization, unfortunately, is unlikely to happen. So it's more the structuration of cyberspace than the fragmentation or non-fragmentation.
But would you say, I mean, Nick, for example, he mentioned blocking as one kind of tool against certain criminal content, for example. And if you look at different countries in Europe, you will see that the laws regarding blocking and the legal conditions for blocking measures are very different. So that would mean you have a fragmented space in terms of the legal system. Doesn't that also have a link to the technical system? Because if you block, you're doing something on a technical level. So at least in that case, where we have different laws, it has an impact also on the technical level, right?
Well, the thing is that there is a difference in the legal rules applying, for instance, for hate speech. A typical example, Germany, France have rules on hate speech that do not fit with the First Amendment interpretation of freedom of expression in the US, which means that international platforms based in the US have trouble respecting the law in some European countries. What is happening is that today, the reality is the solution, the technical solution, and here you have a point, the technical solution is GeoIP filtering, i.e. the platforms themselves, in order to prevent the blocking by the countries, are introducing on their own system GeoIP filtering. Without getting into detail, the interesting element is that it is now contradicting somehow the non-geographic allocation of IP addresses, which used to be a tenet of the architecture of the routing system. And meanwhile, it encourages the different countries to ask for the national distributions of IP addresses, which is likely to lead in some countries where the government is not very democratic to increase surveillance because they can attach the IP address to the device, etc., etc. So you're right, there is an interconnection between the technical layer and the legal layer. But I just wanted to make the distinction because it's easier to deal with the ways they overlap when they do. But start from the separation of the two, if that clarifies the two.
Thank you very much. Jan, you had an additional remark.
I wanted to say that there has to be a distinction. There is a difference, and we have to distinguish the question of regulation of content and of criminal activity. There is indeed a great disparity in the aspiration to regulate content across the world, and that has certain impact. There is a considerable degree of harmony in respect of cybercrime legislation. It is not complete, but the 40 plus countries that are parties to the Cybercrime Convention have aligned their national legislations. But in addition, there's another 80 or so countries that have relied on the standards set out in the convention in order to develop their own legislation. So there is no absolute homogeneity across the world, but there is a significant degree of harmony, which is what the convention seeks, and it is delivering that already now. And it is delivering, in addition to the legal framework, it is delivering also tools and means of cooperation and dialogue in order to implement in a way which is coherent and which can deliver maximum effectiveness. As I said, another thing entirely is the question of content, and there are certainly disparities.
Tatjana, please.
You know, I'm reading Twitter wall, and there is a very interesting comment on Twitter. So I'm citing. So basically, the Cybercrime Convention is a catalog of the kind of tools the spying agencies use in their mass surveillance. So, I mean, maybe we can come to this later if we agree or disagree.
Cybercrime Convention is therefore law enforcement, and law enforcement has to use tools to find out criminals. And what is the important thing is that in a rule of law, you have a basis of law within which to function. And this is what the convention gives. It gives a basis for law enforcement to be able to protect us from crimes, or protect is perhaps too much, but to bring criminals to prosecution. And that is a very important responsibility of law enforcement, but they can only do it if they have the right tools. I'm always, I can't find the right word, but it makes me anxious to read a comment like this with saying, okay, this is what is giving the spying agencies for their mass surveillance. The issue with spying agencies is that it's not transparent. The legal basis is not transparent. The basis for their tools is not transparent. Law enforcement should not be put in the same category, because if the police take evidence to court which is illegal or collected in an illegal manner, the whole case falls. There is another level where we are protected in this rule of law. And so it is an interesting comment to put there, but perhaps we shouldn't be so quick into just equating the two, because they are not equal.
Thank you.
Yes, I wanted to ask to make this clear, the tools that exist in Cybercrime Convention, they're actually also safeguards. You can be sure that you will not be brought into court without using proper tools and proper frameworks, and you can always challenge them. And that's my point. So it's not about spying agencies and tools.
Jan wanted to add something. After Jan, Nick, please.
Well, I'll make a quick point.
Yeah.
I'm not sure that laws are tools. In some ways they are, but I think we have lots of laws saying you mustn't steal, you mustn't murder, and it all happens. So I think, for me, the Cybercrime Convention, it sits up here and sets out what shouldn't be done. But if you're talking about tools, then we're talking surely about ways of disrupting criminal networks. We're talking about finding the intelligence to work out how criminal activities take place, providing tools to the user to protect themselves. Those for me are tools. Now, the law works to a degree, but we can't rely on it, particularly in a global environment. We have to make sure that, in many ways, discussions, partnerships between government, industry, and the end user are taking place, so people are educated. And it's only with that education that people start protecting themselves. And I think that's, we cannot wait for the laws to be implemented across the globe in a perfect way, because it will not happen.
Thank you. Jan, please.
I wanted precisely to respond to that aspect of criminal law that Nick is referring to. And I hope that we do have the opportunity to come back to the other question of whether the activities of national security services are involved in activities that would qualify as criminal activity. But in respect of the question of education, there are two levels at which people have to be educated. One is they have to be educated to protect themselves from that kind of criminal activity. That is very clear. And there is a lot of effort to be done there. There is also the criminal law doesn't resolve a problem per se. We know it. We cannot be disingenuous there. When I was traveling to the UK a year ago, I read as I was going that 70% of reported crime in the UK is not clarified. It's not that there is no final consequence in accountability, in prosecution, and so on. So 30% remains unpunished. There are certain areas where the proportion falls to 10%. We have heard in UNESCO meetings that when journalists are attacked, there is only 10% of effective and successful investigation of the criminal activity. Now, the law is not going to, and we have all these things, there is mafias everywhere, there are criminal activities going on, and law enforcement is not capable of stopping it. Now, the criminal law has different purposes. One is to educate. It tells people, you cannot do this. You shouldn't be doing it. Second, it dissuades people. Many people say, well, I know I shouldn't do it, but why not? And then they are told, but there is a consequence. You will be punished if you are caught. So they feel dissuaded. And then there are others who are not prepared to be dissuaded, and those are to whom the criminal law applies or seeks to be applied. And if it is successful, they will be punished. Don't expect that giving more and more and more law enforcement tools to the law enforcement agencies is going to stop crime. We would end up in a police state, we would end up in a surveillance society, but we will not manage to stop crime. So certainly we have to insist more on the educational aspect, both of the criminal law and education empowering users to protect themselves better.
I'm not sure if a representative of a law enforcement agency would agree with you here, because at least my experience is if I talk with people from law enforcement agencies, you often hear the arguments, well, it is a question of criminal law because we don't have enough tools according to the criminal law that we can use. For example, we don't have enough data. If we would have more data, if we would have a data retention, we would have another quote of clearing up criminal acts. So I think, I don't know if anybody from a law enforcement agency is here in the auditorium. If so, feel free to speak up, but at least these are the answers that I get. Do you think this is...
You are entirely right. It is a matter of giving the tools to law enforcement agencies, but that is the reality in all areas of criminal activity. So you will not be able, unless you go overboard in terms of the capacity to investigate, to penetrate the systems, to gather and sift through information, there will always be criminals that wise up to that and are capable of dodging the law and dodging the investigations. And that is happening today in all areas of criminal activity. And we should not be expecting that in the area of cybercrime it's going to be different. It is not going to be different. But law enforcement has to do the best they can. They have the duty to protect people, but they won't be able to do it 100% all the time.
Thank you. Jean already grabbed the mic.
Yeah, because I was thinking about this. I agree, and there's no solution, and we'll still have crime around us. But what's the good thing of having something like the Cybercrime Convention is that the law enforcement cannot use any tool they come up with. There's a measure of balance. This is what the convention does. It balances rights of people to the needs of law enforcement, and it tries to achieve this balance. Sometimes well, sometimes perhaps less well, but that is the role of law, after all, in a rule of law as well. And this is the, so we should not, perhaps, okay, I am a lawyer, so I will defend laws, but I think there is more into law than we sometimes think. There is a balance that is put in that is very precious. It's precious for us as citizens, and it's precious for as citizens to be protected by the police, and it's citizens to maneuver in this space.
Yeah. But the balance that we have with the Cybercrime Convention has only been signed by 42 countries. Gian, can you tell us something about activities that are carried out in order to encourage other countries to sign this? And do you think that internet governance or the multi-stakeholder approach could be one mechanism in order to, well, encourage countries to sign the Cybercrime Convention?
I'll start with multi-stakeholder involvement in this. And a lot of times we hear about criminal law is only the remit of states, full stop. But states cannot do much without the help of all other actors, especially on the internet. If it were not for ISPs, then the police would be quite helpless in any of the proof they need to collect. And what the Cybercrime Convention has done is, to some extent, given some parameters of this action. So the document that you showed us, Nick, comes from that parameters in some ways. I'll continue on the...
Can I just come in to give some examples? I think we can get very caught up in all this issue around law, and it's extremely important but I think we need to drill down to what's practically possible to make sure that the citizens of Europe and the wider world become safer online, to encourage more internet use. And let me give you 3 examples. Now, these are not perfect, and I'll explain why they're not perfect, but in the UK, and I'm referring to the UK because that's what I've been covering so far, I mentioned these principles, which was a document between the internet industry, ISPA, and government, which sets out some nice ideas, but there are some practical examples. So here we go. 1, cyber essentials. So this is a government-backed, industry-supported scheme to help organizations, particularly small and medium-sized enterprises, protect themselves against common cyber attacks. And you can go online, find out everything about cyber essentials, and you even get a badge that you can put on your website. Now, I'm joking a bit, but it's actually quite important because SMEs need to start doing their education of their customers, and this is just one example. Interestingly, as of the 1st of October this coming year, 1st of October, the UK government will require all its suppliers bidding for certain personal and sensitive contracts to have that Cyber Essentials badge. So then it takes something that's quite theoretical into very practical. You want to do a deal with government and sell goods and services to government, you have to be aware of cyber attacks and cyber security. And even some insurers are also offering a preferential rate to those prospective clients who have this, badge or mark. Second one, there is, for several years now, a thing called Get Safe Online, which is, again, a jointly funded initiative between government departments and private sector businesses. And this is really a signposting. It's a website where individuals, users, businesses can go to get information about cybersecurity. I said it wasn't perfect, little glitch reported in the BBC that when the NCA, the National Crime Agency, last week announced danger, we've got all these threats coming in, it was so successful, Get Safe Online, that it fell over the website. There were so many people desperate to get information and the website went offline. So they've got to correct that one. And then the last one is Cyber Street, which is a very graphical interface online. Have a look at it. You can click, get information, and these are just some of the examples that I think we should start thinking about, not just in the UK, but right across Europe. Education of customers, individuals, and businesses, I think, is a way forward. Not that we don't need an underpinning law, of course we do.
Sorry, can I shortly contribute, and then I will pass the microphone to you. It's actually about Council of Europe Convention and capacity building and so on. I used to think before, like 10 years ago, 12 years ago, when I just started dealing with cybercrime, that without proper legal frameworks, we cannot make any capacity building. Now I'm totally turning this point around. And I think, like, for example, what Council of Europe is doing, even for countries who didn't join Cybercrime Convention, we are trying to build capacity. Of course, sometimes it's very hard without legal framework, but we have to start somewhere. But concerning fragmentation and bad things which are happening on the internet, like referring to sovereignty and maybe like national digital sovereignty or like totally national internet, which is fear for some of us now. This is happening not because of fighting cybercrime. This is happening exactly because of legal frameworks which cannot work sometimes. Like, for example, some of the countries do not want to join Cybercrime Convention because it provides the possibility for trans-border access to data stored abroad. And there is a big discussion on this. And some countries say, okay, this is violation of sovereignty. And here we are in a kind of a deadlock. We cannot harmonize legal frameworks, but at the same time, we cannot really investigate the crimes without these proper legal frameworks. And here we can build whatever capacity. We can invent amazing tools for the police. We can educate users. But when it comes to a crime per se, we do need legal frameworks.
Thank you. Fazania, is there a question from the remote space?
Yes, there are 2 comments.
Pardon?
Comment and question, yeah.
Comment?
Yeah.
Okay, can you?
Yes, so we have a comment from Vladimir Radunovich. What Jan has said is important. Education is the key. 3D printers allow to print guns. Soon everyone will be able to have a gun. Criminal law can't prevent it. Education must. We need a society in which we don't need and don't want to use guns. Criminal law will protect some people some time only. Education can prevent crime. And also I have a question from Kaspar Broden, an independent researcher. Kaspar asks, does the panel believe that EU court data retention decision, paragraphs 56 to 59, prohibit blanket collection versus targeted preservation on geographic zones, suspected persons, times? Thank you.
Thank you. Does anyone from the panel like to answer the question?
If I can venture an answer to that very precise question. If I understand it rightly, the European Court of Justice, the Court of Justice of the European Union, invalidated the data retention directive. So it means the data retention obligations that derive from that have to be put into national law in order to make operators retain data. That directive has been invalidated. Now, it will have to percolate down to national laws. There may be different legislative efforts that will be carried out in the meantime. And it is in respect of the purpose of the directive. So that is the reality. It has been invalidated, but the laws that have been developed and put in place in the different countries have not been invalidated as a result of that, not automatically. In the same way as a directive has to be transposed into national legislation, it will be necessary some kind of adjustment there. But coming back to the other questions, and in particular to the question of the moderator in respect of what is being done in order to promote the ratification and the harmonization of the standards. And I would start by saying, although there were reactions as if I was not supporting the Cybercrime Convention, I am. Of course I am.
It's your job.
But on top of that, it is a very important tool. My comment was that it won't resolve all the problems, and even good laws and good law enforcement will not always resolve all the problems all the time. Now, it is a legal framework. So it says basically those states that sign up to it commit to criminalizing in domestic law this catalog of offenses. It is a framework for cooperation. It permits the states parties to set up a system of cooperation, but it is also an educational tool. It is being used. It has inspired many other countries in their legislations, and the Council of Europe is carrying out a considerable effort to bring the convention to the knowledge, to the attention, and its implementation, the experience, the good practice in different countries, to bring it to the knowledge, the attention of countries all over the world. And there is a regular big conference, which is called the Octopus Conference, on the Cybercrime Convention, that usually gathers around 100 representatives from 100 different countries. In the cybercrime committee meetings, there are at least 60 or 70 countries that regularly participate, and so on. So it is, the impact is far beyond Europe, and in respect of what else, we are doing this, and we are doing it with the strong support of some of our member states, with very strong support of the European Union as well. There are other organizations and other communities that could contribute to supporting the Cybercrime Convention, of course.
What do you think, you mentioned the conference that promotes the Cybercrime Convention, the Octopus Conference. How important is the internet governance ecosystem in order to promote is the Cybercrime Convention? Is that a communication channel as well? Is that the right place, not only to discuss, but also to promote this convention in order to, well, encourage more countries, if they not sign it, even at least to, well, incorporate it in parts where they think it's useful?
I think it's a very good idea. But it is for the community to say it. It's not for me to say it.
That's us, the community. You are the community. You are the multi-stakeholders. Anybody say on this?
If the community wants that message to be transmitted from EuroDIG to the IGF, why not?
That would be,
But it's,
for example,
for
could be a message from the EuroDIG to the IGF in Istanbul. Is that something? No ideas? No questions? Come on. Then I give the question back to the panel.
Definitely. Well, education starts at many levels. It starts from us being aware that it exists and participating in improving this mechanism and seeing how we contribute to the whole system of preventing and reducing cybercrime. It's not just a law, but it's a whole community in this.
I'm actually going to go back to Casper's question, which I thought was quite interesting, whether the ECJ data retention ruling is ruling out banking collection. The answer in the UK is we don't know. I mean, ISPs have been asking the Home Office for clarification. And for me, this flags up this classic debate for ISPs and intermediaries is what is their role? At one point, we collect data, because we're required to under a piece of regulation, the Regulation Investigatory Powers Act. On the other hand, we have data protection laws to destroy data if it's not needed for business purposes. And I think this gets to the heart of the debate for the ISP community or intermediaries is knowing, wanting clarity in the law so that we can behave appropriately. In some places we have it, but in lots of areas, I think the intermediaries are in a difficult position. And, you know, not just in the UK, I think ISPs get leaned on by law enforcement to do more than the law strictly allows. So we do need clarity on the point that Casper made. We're still waiting for it. But it does flag up the whole area, not just in this space, but it flags it up in copyright issues, in other content issues of this concept in the e-commerce directive of the ISP being a mere conduit or a dumb pipe. That clearly doesn't exist entirely anymore because ISPs are doing more. They are looking at protecting people from antiviruses, they're protecting people from spam and so on. Which is more than the strict mere conduit role. So, but clarity is what we do need in this, and we need it legally to make sure that ISPs keep within the law, provide a great service to the customers so they can use the internet for all sorts of wonderful purposes. And I think it's a good question to ask. I haven't got an answer, unfortunately. I don't know if anyone else on the panel can address that.
Well, I can't answer that definitely, but I know that legal certainty is very important, but there's a political game. You mentioned the Data Retention Directive and the UK. Why is it that you haven't gotten, as an ISP organization, you have no clarity yet? Because the UK was one of the ones who had the basis for this even before the directive. So it can very well stand back and say, yeah, this doesn't affect us at all. And they're not really declaring it, perhaps. They're not saying anything, but we're not surprised why there isn't any certainty. But and this is, I think, the role of all of us, is to push for these certainties, because a certainty is very important. It is part of this process of openness, of knowing what is going to happen to you if you do this. This is where we need to go, legal certainty, but it's a longish process.
Thank you, Jean. I'm looking again into the audience. There was a question. Please, go ahead. Thank you. Or a comment. Can you please say your name and who are you speaking for?
Yeah, okay. Lorenzo Pupillo, Telecom Italia. I have a question from the panel. More than once has been mentioned, you know, the role of the European Convention on Cybercrime, okay? But also, I get the feeling that to some extent even the panel, or maybe this is my impression, consider that there is still a lot of work that needs to be done, and so probably the convention is a good starting point, but it's not enough to some extent. From what I know, has this something to do with the fact that it's still perceived as a regional initiative? In other words, what is lacking is the global framework from one side. From the other side, there are some criticism, like the one from Professor Trackman from the Fletcher School. It's considered as the Cybercrime Convention as a cybercrime law enforcement convention, not a cyber-terrorism convention. I'd like to get your idea. In other words, probably do we need a broader framework like an international treaty for that? Thanks.
Thank you for the question, and Tatiana is so keen to answer it.
Or shall we get a set of questions? Because I would like to give you an answer briefly. Yes, Cybercrime Convention is criticized for being regional instruments and for contributing to the fragmentation of the legislation, because it's like one-way ticket. You are either in the club and you can influence what is developed, or you're out. But the problem is that Council of Europe was dealing with this totally on their own. When organizations like the United Nations or the ITU stepped in several years ago, when there was already this instrument with very high standards. So, for example, last year, UNODC met in Vienna with all the countries to negotiate the new instrument, and they couldn't, because it always comes from Russia, China, and Brazil to the question of digital sovereignty, and all issues which are offered are basically blocked. And this is why we are dealing with what we have now. Yes, okay, Europe will never sign anything, for example, will not sign convention coming from the African Union. So the question is, why African countries shall sign the document coming from Council of Europe? But at the same time, they are doing this, and they are implementing the standards just because there is no better instrument right now. And I believe that we have to work with what is done. Concerning cyber terrorism, I'm sorry, there is no such definition of terrorism on the international level. Even if you check United Nations Conventions Against Terrorist Bombing, there is no definition on terrorism. United Nations Convention on Terrorism has been negotiated for more than 12 years with no success because they cannot agree on definition on terrorism. So I don't understand how we can talk about cyber terrorism if we don't know on the international level what terrorism is. So it's like a joke for me.
Thank you. There's another question from the auditorium.
Hi, my name is Manuel Braga. I'm working for Deutsche Telekom. I'm a lawyer, so people say I like laws, and I do like laws. And when I started to read in this internet governance topic a couple of months ago, I was quite happy to find this cyber crime convention, because it has clear rules, clear definitions, rules on extradition, and so on. My question is a practical one. What's the practical application of this cyber crime convention? Has been used often because it's based on a collaboratory regime between countries, which I assume some of them won't be very collaborative despite signing the convention.
Thanks for the question. Maybe, Jean, can you answer it? Are there some practical experiences or examples where the Cybercrime Convention has been implemented and has led to, I don't know, new... Jan Milewski, thank you.
The convention doesn't apply directly. So it is not a criminal law instrument as such that a judge or a law enforcement official, a prosecutor, can say, I charge this person for suspicion of having committed a criminal offense under Article so of the convention. What it says is the countries that subscribe to it have the obligation to transpose that, to create a criminal offense within its own criminal law system. And that, of course, has happened, as I was saying earlier, in respect of the 40+ countries that have done it. that have acceded to the convention, but also in respect of a large number of other countries that have aligned their national legislations to the provisions of the convention. So that is very, very practical and very broad impact. In addition to that, there is a system of cooperation and there of exchange of information, of good practices, and there is all the training and even in respect of digital forensics and so on that is being conducted on an ongoing basis. So there is a lot coming out of it. Now, if I can address briefly the question of cyber, or so-called cyber terrorism as well. The convention doesn't, and I don't think it needs to address specifically the question of labeling some activity as terrorism. Maybe some people think it would be necessary, it is to be discussed. But if you see the way it is drafted, you have the answer. If you are talking about illegal access, if it is done on the basis of terrorist activities or for terrorist purposes, illegal access is covered by the convention already. If it is about system interference, it is covered by the convention. If it is about data interference, it is covered by the convention. If it is massive fraud, it is covered by the convention. So I think that the convention is already there. It is a very valuable tool, and it is a question of, I wouldn't even say implementation. It is being implemented. It's about further implementation and broadening its implementation.
Thank you very much. We have 5 more minutes because we started a little bit lately. So I would like to give the next question to the auditorium. Hi.
I try to be quick. My name is Christian Havelek, and I would like to briefly come back to a topic we have touched on the beginning, which is the relation of the intelligence services and cybercrime, because a couple of weeks ago here in Berlin in a conference, President Schindler, who's the head of our Foreign Intelligence Service, announced a system or a strategy called SIGINT Support for Cyber Defense. So using our capacities to wiretap foreign fiber optic cables to detect cyber attacks and to this extent also cyber criminality, and this is rather a tool not to prosecute cybercrime but rather to prevent it, and it's envisaged to have a couple of our partner services involved, and it has a volume of roughly 300 million euros going to be developed over the next years. And as much as I personally find this a quite remarkable statement, I would like to hear from the panel whether any member of the panel think this is the right way forward, or whether there are any objections or anything. Thank you.
Okay, we have a quick answer from the panel on that. Yeah, thank you, Tatiana.
I do believe that all these confusions about deterring cybercrime and mass surveillance comes from the fact that for cybercrime we have proper safeguards. For preventive police law, which for early prevention, disruption, for national security laws, we don't have these proper safeguards, and these legal regimes are overlapping, unfortunately. And I believe that either we have to separate completely, which is impossible, or we have to reconsider surveillance, preventive police law, national security laws to implement these safeguards. There is no other way.
And a very quick comment from...
Can I just give an example in the UK of how we have the Regulation of Investigatory Powers Act. A lot of people are criticising it, but we also have the Commissioner for Interception, and every year he has to do a full report disclosing exactly how many requests have been sent to the ISPs, and that report goes to the Prime Minister. So there's a level of transparency. And so my answer is saying, to answer directly your question, that is precisely what should happen, that security services should also have to be taken, there has to be accountability for what they're doing, and so we can judge whether it's proportionate or not. And in fact, the report this year for the Interception Commissioner said he's concerned that the number of requests, which number 500,000 in the UK, is a little high.
Thank you. Bertrand, please.
Just a contribution on a few distinctions. There has been a distinction regarding the status under which the ISPs are, and the situation of telco operators is different from the situation of platforms, because in most cases you need a license to operate in the country, and it's the moment where the arm twisting takes place. It's a distinction that is very important for the different actors. The second thing is the characteristics of the Cybercrime Convention, as most cybercrime cooperation, is this based on the principle of dual incrimination. It is trying to harmonize on the level of the substance the different criminal frameworks in the different countries as a precondition for cooperation. The problem is that when you deal with content, particularly on platforms, there will be no harmonization of the substance, because there is no agreement on what hate speech is or not. And so the only way forward in that kind of situation, not on cybercrime, but on content-related issues, is to actually deal with the harmonization, or at least the convergence of the process aspect, and making sure that there is a due process framework that can emerge from the discussion of the different stakeholders. Just use this because it's, of course, an advertisement for the project of Internet and Jurisdiction that I lead. But the question of rule of law is fundamentally a question of establishing due process frameworks for cross-border spaces, which is different from cybercrime, let's be clear. But for content-related issues, we need procedures for the interaction between law enforcement and platforms.
Thank you. And the very last question, and we have to close the session after that. Thank you.
Oksana Prihodko, Ukraine. We are talking about legislation for peaceful times. Is anybody ready to comment legislation for war time?
Was that a question to the panel?
For anybody.
Am I right to understand your question that you ask about legislation for war?
Yes.
For cyber war?
No, just for war. As far as I know, for example, regarding freedom of speech, there are some restrictions for wartime. What is the specificity? It's only the one example.
Well, I'm not aware of anything like this. I think this should go on the national level. I'm not aware of any international kind of frameworks for this. I know that there are some kind of tensions or negotiations on the state level how to deal with wartime, but I never heard they came to any conclusions. Maybe there is something at NATO, but I'm not aware. I don't think so.
Jan.
Answering that question first. The Human Rights Convention has parts 2 to several of its articles, and parts 2 include the circumstances where the fundamental right that is consecrated in part 1 can be interfered with. And one of the causes for interference is usually national security. So that has to, but the question, I think, is so open-ended that one can simply not answer it in this way. But I wanted to say something in respect, and I did flag it earlier, that I would like to come back to that, to the question of mass surveillance. A year and 2 days ago, the Committee of Ministers of the Council of Europe, the 47 member states, adopted a declaration on tracking and surveillance. And one of the indents there reads as follows: draws attention, the Committee of Ministers, so the 47 member states, draw attention to the criminal law implications of unlawful surveillance and tracking activities in cyberspace and the relevance of the Budapest Convention in combating cybercrime. Now, that we know that the domestic law in certain cases tells the security, the national defense agencies and so on, tells them, if you do these things, you are okay. We are not going to consider it a crime. You are exempt from responsibility. This is excluded. Your activities are excluded from the criminal law. But that doesn't apply in other countries. So what you have is a situation where the activities that may not be criminal in country A If they interfere with rights of people in country B, they can be a criminal offense, and it has been signaled very clearly in country B. We have examples of that. We have seen how in the US, criminal procedures are initiated against Chinese military actors, and the other way around. It can happen. So the answer, I think, is something that was said on that side of the room earlier, which is de-escalation. It is about cyber disarmament. Instead of continuing to escalate the system, can't we have a system of de-escalation?
Thank you for that additional and final remark. We come to an end. It would be great if we could suggest something as a message to the IGF in Istanbul, and in this session I think the Cybercrime Convention has been clearly in the focus. Would you think that something like the EuroDIG promotes the Cybercrime Convention as a starting point for a discussion about cybersecurity in a multi-stakeholder manner, something like that as a message from the EuroDIG on the panel? Would you agree on that? Would the auditorium agree on that?
Except content issues. Except legal content issues.
Okay, we will have a drafting session afterwards. No, that was just a suggestion. Thank you very much. I very much appreciate your activity at this time and after 2 packed days. Thanks to the panelists, and, well, thank you.
Friends, there is no break. We will right away continue.
We have the line.
The doors are locked. You can't get out anyway.
Please stay. We have the final session.
It will be short. The final session will be short. It will last only 2.5 hours. 2:25 maybe.
Please take your seats. Okay. Please stay for a little longer. I'm going to tell you what's going to happen next. This is the final session. Thank you for staying. Just a few words to tell you what's happening now. We're going to have a little wrap-up session to conclude the EuroDIG 2014. I'm going to quickly pass to Avri Doria, and after that I'm going to pass to Wolfgang Kleinvector to say some final remarks. We're going to look in a few minutes towards the Internet Governance Forum, which is happening in Turkey, in Istanbul, in September, and then we're going to say a few thank yous. So, just to tell you that for all the sessions that you've been involved with, there has been reporting. There has been a few bullets put at the end of each session. Those bullets, those conclusions will be put together in a series of messages from Berlin, and that's the reason why you're here. Those messages will be compiled and will be transmitted from Europe, if you like, to the Global Internet Governance Forum. You know, the perspectives of Europe regarding internet governance. And so those will be delivered rather quickly. I'd like now to call on Avri Doria to give a short overview in a few bullets about your perspectives, Avri, as a sort of a commentator on the overarching theme, digital society at stake and the future of the internet. Avri, I'd like to ask you, taking a step back, looking at the overarching theme, why we took that theme, not being maybe European or European in heart, what's your what's your take, what's your perspectives on EuroDIG 2014? Thank you.
Okay.
I don't know where that was.
Yeah. Okay, thank you. So I've been lucky enough to sit here and participate. As I say, these are the brief impressions of a US Europhile, and I've been calling myself that a couple times. One of the first things is, this is a dialogue, and one of the first things I noticed in a dialogue is between two parties. So who were the parties here? By and large, the parties were the people sitting up on the dais and the participants on the floor, unfortunately called an audience sometimes, but really the participants from the floor. My perception of the meeting is that the measures that have been introduced in this meeting actually did start creating more of a conversation between you all, more than just a dialogue between two parties. I picked up a bunch of points from the discussion, but there was a few, and I'm just one participant that I picked up. The internet is global, and the periodic talk of a European internet actually runs counterproductive. And I think I actually heard that from many of you, though sometimes there still were people that felt that a European internet would be a good thing. But I think by and large, the impression that wasn't. My personal view on that is even if you build one, it'll eventually be joined to the internet and just be part of the internet like the internet already is. That Europe is committed to human rights, but has very diverse views on how to balance these rights and how to enforce them. And a lot of that discussion came up over the days, that there was no doubt of a very strong commitment to human rights. But as the conversations unfolded, the understanding of those, the balancing of those, which were more important, which were less important, was varied. Multi-stakeholderism means all stakeholders have a seat in the discussion, are part of the discussion. And yet there was really an acknowledgement that at some point in the process, whether it is the technical community, whether it is the legislators, whether it is the business entrepreneurs, that somebody takes the lead when it comes to deployment, when it comes to implementation. One of the points that came out, it is unclear whether democratic oversight of surveillance is possible. Multi-stakeholder work was needed in terms of how to basically do something about that, how to balance the various aspects of security, and the discussion showed that whether it was privacy or whether it was other securities, they really are all forms of the same things, so how they get balanced was a problem. And the last point that I gathered was that the internet is a paradise lost. But it was unclear that it was ever really a paradise. But we want it back. And so basically, you know, it's basically looking at it and saying we should be very careful about the limits we accept on our online freedoms as we move along and try that. I was also asked to come up with a point or two on possible ways forward. Now, again, being a non-European, though I did grow up in Europe, but being a non-European, it's presumptuous of me to tell you the ways forward, but anybody that knows me knows I'm presumptuous. So first, I would say continue expanding the dialogue into a multilogue. I think you're getting there. I think there was so much more conversation, but still at points it gets in, somebody speaks, somebody responds. And it evolving more to that multilogue. Continue to work on capacity building, especially for European political leaders. And then the final thing is I would recommend, though there are points that have come out of all the sessions in terms of messages to send forward, is pick a European policy goal and focus during the year between now and EuroDIG 2015, as opposed to just planning on the meeting, but actually get some work done in the intermediate time on coming up with a greater statement, a greater message to the IGF and to the EU. Perhaps something like concrete steps for finding our way to the internet we want. So again, thank you for allowing me to comment on the EuroDIG 2014. I truly enjoyed being here.
Thank you, Avery. In fact, her comments will be put on the EuroDIG website in a Google or something the like doc. Sorry, in a document, of whatever kind, where you can actually comment on it and have your say on this as well. Now,
okay. Thank you, Thomas. In 10 days or 12 days from now in this room, there will be the first US-German cyber dialogue. And this will be an interesting event because we had some difficulties between Germany and the US if it comes to cyber issues, and which has been discussed also here during the 2 days. And when the organizers said, okay, how to summarize this, they had a good idea to have an American lady and a German guy to rub it up and then to see the differences. My problem is now, I have no differences with Afri. And when Afri said, you know, there is a difficult to find out what is the European internet, it's indeed, we are a global community, so where we have different approaches from different corners, but more or less, you know, we are all sitting in the same boat. The question is, do we move in the same direction, or do we have different ideas to work in different direction? My 3 messages has been said more or less already by Afri. So I wanted to make it very brief and say, you know, rebuild the paradise, reboot Europe, stumble forward. What I mean is rebuild the paradise. It was exactly the point. So the internet in the past was not a paradise, but we had some estimates that the internet is good and gives us more freedom and more human rights. And what we have learned also during those days, 2 days, is that nearly everything in the internet is connected to human rights. And the good thing with the human rights we have learned from the Council of Europe is that we have already all legal instruments there. There is no need to reinvent human rights. It's already there. It comes from the good old times. But as we fortunately have achieved in the Human Rights Council of the United Nations, is that people have the same rights, human rights online they have offline. And I think this is so simple, but we have to make use of this. And I think this was very, very useful that we discussed all the big threats now and big challenges. We did not touch intellectual property rights too much, but this is another challenge where human rights will be discussed in the future. And I think this is really a very, very important message, that everything has to be seen from a human rights perspective. And this is also laid down in the Net Mundial principles. You know, human rights comes first. Reboot Europe. You know, this is indeed, there is no European internet, but the Europeans are not so strong like the Americans if it comes to the use or the application of internet services. So there's a lot of criticism now, in particular in Germany, against Google, Facebook and others. So what I have seen yesterday in the news is that the Chinese search engine Baidu has started now a process of internationalization of Baidu. They start a Portuguese service for Brazil, a Spanish service, a French service for Africa, probably soon also a better German service for Germany. So that you have probably then a choice. If you do not like Google, you can go to Baidu. And then you have a Chinese search engine. So is this a very good solution? Should we start to look for a European alternative? Where are the Europeans in this big game? And we had a very fantastic economic session here. I think it's for the first time in EuroDIG that we discussed this more business-oriented details. So we need this young generation. I'm also very happy that more young people than ever came to the EuroDIG meeting. Probably for me, I'm in my 60s, a 30-year-old person is a young person, but probably we should invite also people in teenagers or in their 20s, because they represent the future and they have a different approach to this. And we should listen to them, because they will have the opportunity to reboot Europe. And we should make it as easy as possible for them, and not to protect the past, but to open the doors for the future. And the last thing is stumbling forward. And the last message is stumbling forward. I think this is this fantastic definition from Bill Clinton when he was asked what internet governance is, and he said, it's stumbling forward. There is no master plan. So we are moving into uncharted territory. We have to find a way, how to build this uncharted territory and what to do with this. So this is step by step. There will be no big jumps. There will be small steps, and we have to accept that we go step by step, slice by slice. And I think the Net Mundial has pushed the whole process further forward. And the process of multi-stakeholderism, or the multi-stakeholder model, is now more and more accepted. But there is a risk in it, in particular for the young generation, which did not go through the process of the last 10, 15 years in a fight for multi-stakeholderism. For them, it's very natural that they can raise their voice and that they are part of this community, and that the foreign minister now from Germany says, okay, we as a government, we are part of this broader community on an equal level. We queue up in Sao Paulo and wait until we get 2 minutes to speak. So this is really new, but for a newcomer, this is now already a given fact. So, and then we should be very careful not to overstretch this discussion on multi-stakeholderism and to treat it as a religion. Multi-stakeholder processes should move from reflection to action. We should to practicize it. So it's very important to clarify further the concept, to understand how it works. But it's much more important, really, to do it on a day-to-day basis in our when we deal with the issues. So stumbling forward with small steps on the basis of the multi-stakeholder model is probably a good guideline for the next years. Thank you very much.
Thank you, Wolfgang. Okay. Thank you, Wolfgang. Thank you, Wolfgang. This week in Geneva, it's a very big week for the UN and for the Internet Governance Forum, and the WSIS, the World Systems and Information Society +10 review. It's a very important week for the future of internet governance globally, and that's a very important point, because we're looking now to the next chapter is the Internet Governance Forum in Istanbul on the 2nd to the 5th of September. And I'd like to call the next speaker, Chengetai Masango, to say a few words, and I'll just raise it up a little bit for obvious reasons. Thank you, Chengetai.
Thank you very much, Lee. First of all, thank you. I go to many regional IGF initiatives, and I've never ceased to be amazed by the organization, the participation, the depth of discussion that I find at the EuroDIG. And it's also a very innovative space. There's always something new when I come here. There's always, you are always trying something new, and sometimes we do copy those to the global IGF. I would also like to congratulate the host, ECO, the Federal Ministry for Economic Affairs and Energy, and the Federal Foreign Affairs Department, and also to Sandra. I know she's been working very hard in the background, Wolf, Lee, and Thomas, and of course the team. Thank you. I mean, it's really been outstanding. Outstanding. Now, for the IGF 2014, which, as Lee said, is going to be held during the first week of September in Istanbul. And the main theme is connecting continents for enhanced multi-stakeholder internet governance. In this IGF, we are instituting some of the changes that have resulted from the report on the improvements to the IGF from the working group report, and also taking up some of the challenges that were presented to the IGF from the Net Mundial meeting in April. One of those tasks that we were given, or challenges that was pointed out, is to further integrate the regional and national IGFs into the global IGF. And we are going to have a inter-regional dialogue session at the IGF, but I also do encourage all the national IGFs that are here to contact the Secretariat, register at the Secretariat, join our mailing list. We have an inter-regional IGF's mailing list. and help us work together on how we can integrate the input from the regional and national IGFs into the main IGFs. We also plan from this IGF also, it has to be a two-way process for the national and regionals to feed into the main IGF and also back and forth so that we get a feeling of the distinction and the main concerns of the regional and national IGFs. We also have best practice sessions that we are trying a new twist to this time around. We've picked 5 of them from developing meaningful multi-stakeholder mechanisms, which I'm sure you've been a part of, and you can contribute to that best practice, to child online safety. And we are going to have some mailing lists, and in the IGF website we have a community site where we're going to start intersessional work and discussions on these best practices in a view that after we hold the best practice sessions at the IGF 2014, we are going to produce a booklet of best practices, what to do, and probably as well what not to do. And with these, we're going to distribute them to organizations and they may find them useful. Also joining in for the IGF, if you cannot come to the Istanbul IGF, we do encourage you to come and participate online. We make a great deal of effort onto our online remote participation, and you can join in. We've also got a YouTube channel that people can watch, and it's very easy. There's no time lag with that. For organizations, there's the IGF Village, and the deadline to have a booth at the IGF Village is the 30th of June. In the IGF Village, we are also going to have a speaker's corner. So if you did not have a workshop or a best practice session or an open forum, there is still a space for people to come and have their say and present any initiatives there at the IGF Village. We'll have a sign-up sheet and people can just sign up for a 30-minute time slot and they can speak. Registration for the IGF 2014 is going to start by the end of this month, so please just watch the IGF website and you'll be able to register. If people need any help with visas, etc., the host country has been very gracious, and if you have any problems, there will be contact numbers for that. And with that, I'll end.
Thank you, Cengiz.
That was short, right?
That's perfect.
Thank you very much. Any questions? No.
Thank you, Cengiz. Thank you for your help. Okay. Now we have to, Michael, come up please. Michael Rutter, thank you very much. Thank you for coming a little bit later. This is the main man, he's the main organizer with his team. Without Michael, this would not have happened. Michael, the floor is yours.
Thank you very much. I think that this EuroDIG has again shown how multifaceted the internet is as a technology and as a medium for communication, but also how numerous, when I watch discussion just this afternoon, the unanswered questions and challenges are which we are facing in connection with the internet. In short, we can only meet these challenges in dialogues and in concert with all those involved, stakeholders from industry, politics, academia, and the civil society. And to give you some numbers on these stakeholders, we had 770 registrations. We had about 500 people here yesterday per day in parallel, roughly. Today a little bit less. And from these 770 registrations, roughly, the 4 major stakeholder groups are 120 plus minus 20, so they are nearly equally equipped from these figures, and the people came from over 67 countries. These are some figures. We will, of course, this will be sorted out and published on the website just to give you, before you travel back home, some figures to report. Europe has now, and this is what has shown by the discussion, not only today, but also yesterday, Europe now has the opportunity, but at the same time also the responsibility to take on a stronger role in internet governance in the future and to push for the recognition of basic European values in the digital society. And I would like to encourage the Council of Europe, for instance, when I see this development with all these figures, to facilitate more solid and long-lasting arrangements in view of the support of the various committees, including the CDMSI, or the CDMSI, or the Committee of Ministers. And I think that this is worthwhile to strengthen the organization of EuroDIG. When it started in 2008, there were only 200 something attendees, and now 770 registrations. And I think it's time to move to maybe different organizations and to longer lasting institution, no matter, by the way, what happens to the international global IGF. If it disappears, Europe can still stick to those values we are working on, we are discussing. At this stage, I would like to thank the German Federal Ministry of Economics, I don't see anyone from there, which had the patronage this year, and of course our the Foreign Office, which made these magnificent rooms available to us. And from the Foreign Office, I need a mic, or not. I need a mic. Kathleen. She was the ghost working in the back. Kathleen, thank you very much for your effort. Without her support, it wouldn't have been that easy to come in and out and all these things. But anyway, the rooms are, and the facilities here are very good for this event, and underlined also, hopefully, the results. Many thanks, of course, also to the entire EuroDIG team around Lee and Thomas. And we have a lady in your team as well. Sandra? Sandra Hoferichse. She is the one, without, you wouldn't have been able to register. Thank you very much. And of course, Wolf, I didn't forget you. Thank you very much, you as well. And of course, my ECHO team, I mean, I can stand here and can give some talks, nice talks, or not so nice, whatever it is, but without my team, I'm just nothing. So there are a couple of, and you see, a row of ladies. It would take hours. You have both. Thank you very much, Sandra, for the support. She's the head of the Berlin office of ECHO. Blau zu blau. Thank you very much. Now. Oh, thank you very much. Mary, she was the ghost in the back. Immer her. Ups. Thank you very much, Sidonie. Next one. Hi, okay. Thank you very much, Mr. Larsen. So, those were the ladies listed from the team, and as I said before, thank you very much for the tremendous work you had in setting this up and making this EuroDIG 2014 the huge success. Thank you very much. And Wolf, it's your go.
Well, I will just hand it over to Lee immediately. Just to make clear once again that the event is one issue. And what you had the pleasure to attend the last 2 days. The other part is a process. The next EuroDIG starts now. So, and it goes to Istanbul, as we said, and afterwards we have the call for proposal, and the programming for next year starts immediately. And in this entire process, there were 2 more people closely involved, 3 more people closely involved for a long period of time, and without their support, all this wouldn't have been possible. Lorena, yes. Sorry, this was not meant that you fall when I call Lorena. Lorena, please, come up. Hey, come here. Lorena was in charge of the new instrument we introduced, what was the wiki. She was extremely supportive on all levels. She worked a lot with us, and without her support, it wouldn't have been possible. There is Fasane, please. Come on. She is in charge of remote participation. She's also one of the great souls in the back, and without her, nothing like this could have made possible. And we had Sebastian. Sebastian Hasselbeck, please. Come, Han? Oh, he's gone already. Oh no, here he is. So he's also more or less coordinator of the digital facilitators. They all were of great support and for the whole process, and I think we can count on them in the next process for 2015 as well. And I give back, huh? No flowers.
This is discrimination, gender discrimination. We will protest at the next EuroDIG. Or create a working group.
Okay.
Sorry, this was a little bit...
Let's rather finish than discussing gender equality and flowers for men in the future. We'll see. Maybe we make it a topic. But coming back to the event, without money you can't run such an event. So many thanks to the sponsors who finally made this EuroDIG event happen. Also the major sponsor D6, where also the technicians are from, who made the Wi-Fi available, and for me it worked, and I've not heard any complaints that it was not working. So give a hand to the technicians for the Wi-Fi, please. And Last but not least, I would like to thank you all, the participants, locally as well as remote. If we still have remote people, you are the soul and the voice of EuroDIG. Without participants, the stakeholders are missing. Huh? And finally, after the event is before the event. And I'm already looking forward to the next EuroDIG, which will take place next year in Bulgaria. And on that note, I would like to officially hand over the EuroDIG flag to Ilya Baslyankov from the Core Association. Here you have it.
Thank you. I'm really happy that the next meeting will be in Sofia because it will help also the local community to become more engaged in the discussions. Our greatest success with multi-stakeholder discussion in Bulgaria was the IDN.BG project, which some of you know that still hasn't happened. The meeting next year will be most likely in June, as it proved to be a good month. I would like to invite all of you to come to Sofia. And now I would like to show you a short video of Sofia.
Thank you very much. So we hope to see all of you in Sofia next year. We have no date yet, but that will come up soon. And now the thing is over. EuroDIG to 2014 is over. Somebody needs to thank Michael, the person who's sitting here in the middle. I guess you've seen him. You know who he is. Thank you very much, Michael. And your team. And just one reaction to the flower discussion on Twitter. In the EuroDIG team, there are no bosses. We are just one team. And the women get flowers. Maybe the men get a German beer later tonight, and then we're all happy and get what we deserve. Thank you very much. Have fun. Enjoy Berlin. And thanks to Lee, of course, as well.